I say a couple to the flex they represent for Wayne Global TV. So I say, you know the code in the Wayne Global TV is what fully blessed on the 90 days. So I say, yeah man, to the fullest. Yeah man, make sure them log in to Wayne Global TV. So I say, check it out. So I say, one cup of flex. So I say, Wayne Global. When you watch you know, see them a plan up and a try to put them money pan we head. But man a live too long, them want Wayne Global fitted. To him juggle so smooth that them want him life for dread. I throw the bank a light the break, but we ain't all about the bread. Open up on the ears and no listen when we said, cause we lyrics them so smooth like the linen on the bed. Them one with a fall, travel living on the edge, I must say true, we make this them. We in Global TV, we are 90, and 90. Who Jaja bless, say no man can curse. Give me the Range Rover, who no drive years. Boom! We in Global TV, to the fullest one cup of excellence, see me?
Good evening, and welcome. Thank you all for joining us. Welcome to another Drive Time London Lunchtime Global. And this evening we are continuing the Vybz Cartel justice debate in response to an article wrote by PJ Patterson and Hugh Small on the 20th in the Gleaner, as well as the Gleaner's editorial in today's publication entitled DPP Did Nothing Wrong. Good evening and welcome. Thank you for joining us. Good evening to my community of parity. Good evening to all my family members. Good evening to all my moderators, my members, subscribers, viewers, and followers, supporters, good evening and welcome. To those of you, the 30% of people who are watching global television and is not yet subscribed to global television, what are you waiting for? Hit the subscription button and come on board. Join the globalist family so we can all think, explore, and learn over here together. Good evening and welcome to those on the X, on Twitch, on Facebook, and on YouTube. Good evening, all, and welcome. Corrupt or incompetent justice? What do you think? Have you seen the Gleaner article by PJ Patterson and Hugh Small? Or have you not? But what is your opinion on justice in our country in light of all of what is coming out of the Vybz Cartel case? Incompetent justice or corrupt justice? Incompetent justice or corrupt justice? I notice the propaganda from the state and the office of the prosecutor, or probably some media house aligning to them. Even the defense team are saying so, that the public debate we're having now could somehow or other jeopardize justice or whatever. Let me say to anyone advancing that argument with regards to justice, everything we're discussing in the Cartel case has gone through the entire Jamaican justice system. It has gone to the highest point of the Judicial Privy Committee of the Privy Council. All of the court decisions are out there in public for us to read. There has been several articles globally from 2014 up to now, when he was convicted in 2014. There were articles around the time, even publication of some of the court transcript with regards to the telecommunication evidence that the text messages between Cartel and others who were on trial then. There are a raft of information out there for us to assess and debate on, as well as we are allowed to speculate given what we know now. If the courts and the legal professionals are competent enough to deliver justice, then they shouldn't be worrying about or debate. Cartel case has been under the spotlight since 2014. The discussion now will not make a blind difference to the publicity. Yes, there are a much broader discussion in the social media landscape now than 2014. But if the court is competent, it shouldn't be able to deny justice. Patricia Matthews, good evening and welcome. Good evening and welcome to Debbie Jervis. Good evening, Michelle Lewis Wilson. Good evening, Sunshine. Carol Sexy Sade, good evening and welcome. Violet Watson, good evening. Miranda Ruddock, good evening. Marlene Garden, good evening and welcome. Janet Malong, good evening and welcome. JC. Mary Messenger TV, good evening and welcome. Jason King, good evening. Joan Brown, good evening. Good evening to P. Richards, good evening and welcome. Jason King, good evening. Look at TV, good evening and welcome. Georgia Dennis, good evening and welcome. Lennox Reed, good evening and welcome. Sharon Peart, good evening. Pauline Dixon, good evening and welcome. Marie, good evening and welcome. Veteran, big up yourself, well gone. Monica Hawthorne, good evening. Sharon Pierce. Good evening. Good evening, Tash. Good evening and welcome. Good evening to you all and welcome. Thank you all for joining us. Rosalie Ricketts, good evening. Before I get into my discussion, I want to play what in my view, is quite a useful and relevant piece of information. Just let us listen together. It's the current state of the world order we're in, and hopefully you understand what she's explaining. And even though she's making reference to America, don't just see it as America, but the whole world or the global West. Kids at Clothing Club, good evening and welcome. So let's listen in.
Really use words of art to make you believe, in fact, that law is on the table when you walk in. Use law, really use words of law really is. Most of us think that we go into a courtroom and understand the difference between a court and a courtroom, that the people who purport to use law really use words of art to make you believe, in fact, that law is on the table when you walk into a courthouse or a courtroom, when in fact that's not true. And I would like to share with you tonight, regardless of your religious persuasion, what law really is. Law, and as Muslims would say, all law, is A-L-L space L-A-W, all law, all law. So for anyone who's of a Christian persuasion, don't be misled, and when you hear the term all law is God. All right. That is also what we would say in lawful terms, a misnomer. Allah is not God. God has no capacity and no standing to all law, because God means governmental ordinance departments. There is no comparison. Now, who can use law? Law can only be used by people who are in their sovereign capacity. And as I will share with you tonight, the majority of the people in the world, and I'm not going to get into all of the details about that, but the majority of the people in the world, 99% of them live in slavery today. So in 1863, via the Emancipation Proclamation, and I challenge you to go look in a law dictionary and look up the definition of emancipation and proclamation, and you will see that a proclamation is not a law. A proclamation is a public announcement by elected officials. It is not a law. So the Emancipation Proclamation of 1863 did not set any slaves free. What it did was standardize slavery, the United States being the model for the standardization of slavery, that all of the other nations around the world, as they reduced their people from their sovereign capacity and forced them to join nation states, they are in a corporate ward status, meaning that they are wards of the state. They are members of the corporation, which is a nonprofit that calls itself the Commonwealth of Pennsylvania. And as long as they have a birth certificate on record with the Commonwealth of Pennsylvania, with that birth certificate being a contract, a birth certificate is a contract. And as long as you have a contract with the Commonwealth of Pennsylvania Incorporated, you belong to them. And that's what slavery really is. Right? So who can use law? If you are a member of a corporate ward state, if you are a member of a corporate ward nation that calls itself the United States of America, you are a citizen. Look in the law dictionary and look up the definition of citizen. A citizen is not a sovereign. A resident is not a sovereign. Therefore, if you use an address, which is a fictitious number associated with a designation issued by a corporate ward, right, then you become under the jurisdiction of those people who are also corporate wards, but who are also slaveholders. All right? So if you are operating in that capacity, law does not apply to you. If you are a resident of the city of Philadelphia, which is a private nonprofit corporation, and you say you are a resident of the city of Philadelphia, then the ordinances and the resolutions of that private nonprofit corporation apply to you. If you are a citizen of the Commonwealth of Pennsylvania Incorporated, which is a private nonprofit corporation, then the statutes of that nonprofit corporation apply to you. If you are a citizen of the United States of America, which is a private nonprofit corporation, then the code of the laws, right, apply to you. But if you are a sovereign of the Moorish Empire, those ordinances, those resolutions, those codes, those statutes do not apply to you. because you are not a member of the corporate ward state. It's as simple as that. And they understand the difference. This is why on their documents, they use words of art. They use the word label. They use the word person. They use the word address. All of these things that place you in their jurisdiction, and you unknowingly fill out forms every day. And every time you fill out a form, you enter into a contract. I don't care what kind of form it is. It's a contract. A driver's license application is a contract. A social security application is a contract. When you call up the telephone company and you make a verbal contract over the telephone, this is why they can bill you. When you sign a deed, it is a contract. When you fill out a voter registration form, it is a contract. Does everybody understand that? Don't ever think anything that you put your signature on becomes a contract. All right? Now, the fact that you are not in your sovereign status means that you make a contract as a minor. They don't care. They know you are a minor because, and to be other than a minor, I'm going to start with what law really is.
I think that was useful information. It is the current state of play. I don't remember if any of you ever hear me said, we've never really come out of slavery. We were transported from slavery to colonization and then to corporation rule. She gave quite a good explanation. Sharon Peart, real sweet, Flo M, good evening. She gave quite a good explanation, breakdown of how we were transferred into corporate rule, which is a standardized, normalized slavery, rather than the shackled slavery or the direct white rule to colonization. So I thought it was useful information to bring to you because it makes sense. Let me share my screen. Let me share my screen here and ramble through these two articles. And then I will go on. So let's look at the PJ Patterson article, PJ and Hugh Small article, both men or distinguished King Counsel now, rather. Bear with. My system is just running slow. No, that is Madam Parlor. Why has it gone to something else? That's not what I had it on. Yeah, that's you. PJ Patterson. Oh, why this thing keeps... Gleaner, please. I'm not going to pay anything. Just leave us alone, will you? Right, so I hope you all can see this. So I'm going to ramble my way through for any of you who have not read it yet. Let me look, let me now go read it for you. I'm going to explain to you about it. This article with PJ Patterson and Hugh Small wrote, it was about a decision from the Jamaica Appeal Court in 1983. In case law, in context of case law, judge's decision, such an important ruling coming out of the appeal court is what you would call a very recent case law or a very recent important case. Now you have within the justice system, when you get to the upper courts, such as the Privy Council, such as the appeal court the Supreme Court or the High Court. I don't know how it's situated in Jamaica, but if you're following the British model, you have 3 different branches within the High Court. You have the criminal division of the High Court, which only see criminal cases. Then you have the civil division, which is called, I think, the Chancery. And you also have the Queen's Bench. So within the High Court in the United Kingdom, that's the setup. You have 3 different branches. You have the Queen's Bench, the Chancery, and the Criminal Division. They hear based on their jurisdiction. But when you get up to the Appeal Court, you only have 2 divisions. You have the Criminal Division, which hear everything coming from the lower criminal courts. And you have the Civil Division that hears everything that comes from the civil section of the appeal, the civil division of the appeals court. Why I'm explaining this? Because it's important to the judgment that P.J. Patterson and Hugh Small wrote about. This decision was in the appeal court, but it was in the civil decision, the civil division of the appeals court, while the Cartel case was in the criminal division of the appeal court. Should that be a good enough excuse why during Cartel appeal, nobody, judge, prosecutor, or defense, seemed to be aware of this important ruling to do with jury trial and jury misconduct or tampering? So this case they were speaking about is a defamation case, which involves Prime Minister Manley, which was the defendant, and the Gleaner and what's the man called? Is it Heron? Were the claimant in that case. Defamation cases are tried by jurors. Rosalie Ricketts, good evening, good evening. Head teacher K, how are you? Good evening. Defamation cases are one of the very few civil cases that are tried, that are jury trial. So this was a jury trial defamation case in the appeal court. This decision was from the appeal court, but the civil division. This should not have this important decision, right? With regards to precedents, you have 2 types of precedents. You have binding precedents, which all courts and all judges must follow. For example, if the High Court sets a precedent, then every court below that the High Court must follow. If a case comes to them that have similarity to that case which creates the precedent, then every court below the High Court must follow that ruling when a case comes in front of them which bears the same similarity of that case which sets the precedent. You have 2 types of precedent. You have what is called binding precedent and persuasive precedent. You must follow the binding precedents. the persuasive precedent as well. You must, even if you are not following, you must take it into account. You must refer to it in your judgment, and you must state why you are departing from that persuasion. When a case gets to the appeal court, when you're going up for an appeal, Amazing Grace, good evening and welcome. Every lawyers and judge who will be involved in that case, all of that legal team would go on a deep case law research. Now, let me roll back. When the jury debacle was going down in court at the end of Cartel trial, fair enough to say nobody wasn't aware of that 1983 ruling from the Jamaican Appeal Court, where they've discharged the jury and started the trial afresh. Now, when the debacle was going down that day at the end of the trial, when Paula was summoned to court, if anyone was aware of this case and not make mention to it, including the judge, then that's poor legal knowledge, because this is what is called a very recent case in case law history. Very recent case. This is what you would call new law. In the common law terms, this is what you would call new law. Okay? Nobody, it seemed to all bypass everybody then. But when you got to the appeal court, let me bring back up the article on the screen. When they all got to the appeal court, this was not excusable. Why? Because, as I said before, everybody, prosecutor, defense, and judge, everybody go in, because bear in mind, the issue in Cartel case here is to do with juror misconduct or juror tampering. Now, a simple research in 2014 and beyond, we had and ongoing, we had access to internet where there was that possibility to do legal research and on the internet. It wasn't the days when you have to go in the library and turn a library for hours, sleep a library overnight, because you are doing deep research. Legal research now, there's a lot of legal database online, or decisions from the upper courts are all out there in public for anybody to go and research and read. So if all of these people who are going to the appeal court were competent enough and they were preparing themselves, what the type of research they would have done is case law. All you have to do is type in your search bar, case law on jury discharge, case law on juror tampering, case law on juror conduct. You're going to find something. You are going to find something. Given that they are legal scholars, they have access to legal database, which some people don't know. There's this legal database where you can go find all sorts of cases. From the days of we're going to university, we know where all of these different legal database or law reporting sites are, to go and find whatever cases we're looking for, because when you're doing legal research, you know the issue area that your case carries. So you are going to search for case law that have that issue area. How did these competent people miss such an important case? A case within the appeals division, albeit in the civil division of the appeal court. It doesn't matter. Legal research would tell anyone, and it doesn't matter because this is defamation and this is criminal case. It doesn't work like that. It's about, are the issues similar? Lanford, good evening and welcome. And this very important case, the Gleaner and others versus Michael Manley, where the Supreme Court ruled discharge a juror and ordered a retrial. This should have been done in Jamaica in 2014. So to be back debating a retrial, it's a waste of time for state and justice. What we ought to do is to get the system fixed, put in the necessary measures, do the lesson learned from the Privy Council's judgment, and put in the necessary protective measures that protects justice rather than denying justice. When both prosecutor and defense are going to like the Privy Council, you would want to prepare sometime a lot more. You would have a lot more case law under your belt to argue, but at least 6 or 5 case law you're going to refer to the judge for consideration of your argument. At least 3 of them must be in the line of binding precedents or strongly persuasive. If there's nothing in your jurisdiction, Jamaica, you can look in Canada, you can look in England, you can look in India, you can look in Nigeria, wherever the Commonwealth exists. You can look in that jurisdiction to see if there's a case law there that deal with that issue that I can use to guide me in my decision. This Gleaner and others versus Michael Manley was a very perfect case, sitting in our Jamaican jurisdiction. A decision of 1983 is a very fresh decision, which anyone in the legal profession should have known about. A judge not aware of such an important judgment, and a justice not aware of such an important judgment of the appeal court, for me, is hugely incompetent. Because when lawyers, both prosecutors and defense, are incompetent in such a case and fail to pull out the most important case in the land to do with jury tampering, misconduct, or bribery. We had that case sitting there when the 2014 Cartel, when the 2020 appeal case was going on in the appeal court, the 2019 to 2020 or so. That case, which was the guidance which should have sent Cartel case back for a retrial before it gets to the Privy Council, was sitting there. The prosecutors didn't seem to be aware of it. None of the lazy defense then seemed to be aware of it. The judge himself we're all right if them two they fail. The judge, after listening to both of you, should have said to you, here is an important case in our jurisdiction to do with juror conduct. But I don't see any of you bringing it up, and the judge should bring it into his argument when making his decision. That is what good justices do. That's what they're there for. To guide the law, to protect the administration of it. But Justice Lennox Campbell Shamble fell woefully short on that day. Likewise, the appeal court Justice Patrick Evans, who upheld Justice Lennox Shamble's decision, and by extension submitting questions to the appeal court, the Privy Council. The Privy Council, after looking at the documents, didn't want to look at more than one liberate period. Good evening, how are you? Abena Sadoki, how you doing? I thought, no man, me there come this evening. So the judge not able to bring it into the case was hugely incompetent. By them upholding Lennox Shamble judgment, submitting those questions that the Privy Council answered, they should have been competent enough to answer those questions themselves. They submit 3 questions. The Privy Council didn't need to answer more than 1. Why they answered the jury tampering only? It was enough to throw the case out. They didn't have to consider the evidence side of things. They just had to look at the juror bit, and that was enough for them to quash the conviction. Because our entire legal circus on our island failed to apply the law properly in Cartel's case, failed miserably to observe natural justice, which I will move over onto with the Gleaner article, where them I say, Parla did nothing. DPP did nothing wrong. Now, a competent DPP, let me see if I pull it up wider. Hold on a second. Let me push her right in on her face. Right, now a competent DPP, even though she's the prosecutor in an adversarial system, our justice system is a football, bat and ball cricket system where each side is playing to win. It's not really about you, it's about people in the legal profession getting a win under their belt. It's good for their profession and their status. So when Paula was summoned to the court for her opinion on the juror conduct which was unfolding in court, she's not denying that she admittedly had no problem in the judge sending the what you call it, the poison juror into deliberation. Simone Bedford, good evening and welcome. That was the very problem. as the prosecutor, even though you're there to prosecute, but because you are under a duty to prove the accused person's innocent, you are also under a duty as a consequence of natural justice to be fair and protect the accused right throughout the whole trial process. So as the prosecutor, all of us who've been through the legal system, understanding the laws are the rules and regulation around the whole juror system and the threshold for conviction, guilt beyond reasonable doubt. As long as there's any doubt anywhere in the case, a juror cannot convict or should not convict, because something in your mind provides a doubt, and that means you're not sure if the person is guilty. So to give a wink and nod to the judge, to say, I don't have a problem in proceeding with a tamper jury pool. That is the very problem that Uno a walk and talk say you know do nothing wrong. And that's the problem. You disregard the fair process of justice. You had no regards for natural justice when you did that. That was wrong. The Privy Council said it was wrong. The justices of the highest court said it was wrong. It was fatal. So to be still going around and say the DPP did nothing wrong, what the DPP should have done is what the DPP is doing now in the firearm case, which even that one, the DPP is going wrong about it. The DPP is going wrong about that one. What she should have done when the judge summoned her in Cartel case in 2014, she should have taken over, pull the trial. She have a constitutional power to do that. Pull the entire trial and start trying afresh. She rather went ahead with a tainted jury. No one knows why. If it's because they knew they wouldn't get going the fair route, they probably wouldn't get a conviction. One have to wonder why they continue down that slope. But with regards to the Section 5, Section 45 confusion, because the justice system has made the mistake, put the wrong section on the indictment, the young man pleaded guilty and was given his sentence. The director of public prosecution realized she made a mistake after all that was done. When in the justice system you realize that, rather than going to the appeal court, asking for the appeal court to quash his conviction so you can charge him with the appropriate charge and take the trial back to court. This is what the DPP has done. What should have been done? James, good evening. Big Bossy, good evening and welcome. Good evening. Is take to the court what is called a case stated appeal. The appeal court would give a clarification, a ruling which clarifies the issue. And that issue would set there to guide indictors forward, rather than making that horrible mistake that Paula office made by putting the wrong section on an indictment. That should have been done in a case stated appeal, rather than applying to the court to quash his conviction and then want to retry him, because it was the prosecutor's mistake. But that is the incompetency and the corruption of our justice system, where even when they made their mistake, you are expected to bear the brunt of the law. The Cartel case has gone on long enough. It has now become a global embarrassment for the Jamaican justice system. It is time that this thing is stopped. At this point, there will not be fairness. There was not fairness 10 years ago when the evidence and the incident and everything was much fresher. We've learned that the police tampered with evidence. You cannot expect to go back to trial with tampered evidence. Drop it. It's enough. If he's guilty, you have messed it up. Justice delayed is justice denied. You would have denied Lizard mother of justice, as well as you would have miscarried justice in these accused people's case. You, the Jamaican justice system, have messed it up from start to finish. The tampering of evidence by the police does not afford one fair trial. It's not a part of the natural process of justice. It will not meet the bar at the Privy Council. If the corrupt justice system in our country put it through, it will not meet the bar at the Privy Council. You did not investigate the case properly. It is your consequence. Guilty beyond reasonable doubt must be proved by the investigators who gathered the evidence and the prosecutor who prosecutes the case. You all did not do that. You moved in from the very start to start with corrupt practices. I will call you back shortly. I realized my phone had up on silent. Dart White, good evening and welcome. This case was messed up from the very start. The police, rather than doing the proper investigation, bringing in the proper teams that they need to bring in, to do whatever investigation they need to do to provide the evidence to secure a conviction, they went ahead with tampering the evidence. They went ahead with tampering the evidence. If these two men are aware of this case, it would have been well aware of in a lot of senior counsels in Jamaica. When an important ruling, when you're in the legal profession, this is why I'm interested in a law practice or don't want to practice law. Practicing law is a blind use subject. It's a subject, it's a practicing law blinds your eyes. When you're a legal academia like me, you can get away with certain things. You don't have to read certain things. But when you're a law practitioner, you have to read every new legislation. Every new ruling come out from the court, you need to read them. Every new regulatory paper or whatever come out, you need to read them. You also need to read just judgment sometimes from other jurisdictions. David, good evening and welcome. It's a profession where you cannot stop reading, because if you're getting a when you go court and you're getting a court and things that talk about what you don't know about, you look woefully stupid and incompetent. Colin Humphreys, good evening and welcome. So you have to keep yourself abreast of everything. You have to keep yourself abreast of everything. So practicing law is a blind use subject. So I'm interested in them something that I meant to show you all a way to find information to read without buying books if you're a person who is interested to read, and you all must get reading. It is very important. It make them a treat you like fool because we not read. Now here is on a phone or anything on the phone, you can just type in Google Books. Once it hold on there. You just type in Google Books. Within that Google book, you go there and you type in the name of any book or anything you're looking for to read. Africa 101. See? I type in Africa 101, it gives me Dr. Chiambori book. This is a very great read. I do not have the thingy copy because I no longer buy books in hard copy. I buy the Kindle version, the Kindle version. But this woman book is also a great read. And when you go into Google Books, you can find a lot of important bits of the book, a lot of important highlights of the book, which you can read from. So you can just type in Google Books and you can read from that. Also, for those of you who do academic researches, Google Scholar is there where you can look for journal articles and all sorts of studies and this and that. But we need to get reading and get ourselves informed. So one of the pound of phone sometime and want to do a quick read on anything, just go to Google Books or Google Scholar and type it in, and it will certainly give you something of interest to read. There's always something to find to read on Google if you are interested in getting into the reading game. Now, Google Scholar is more for those in the academic field, but it doesn't matter. Anybody can read. So if you're looking for like cases, case laws, or articles, or whatever, I'm just making sure you're seeing my screen big enough. Hold on, I want it right up in on the face. So whether you want to search for articles, journal articles, or case law, Google Scholar is your place. You click on case law, it will ask you to select area. You can select where you're looking for case. A lot of this have to do with the American case law system, but you can also type in if you're looking for UK case law as well. But the Google Books area, if anybody tell you about any books and you want to like read a snippet of it or so, always go to Google Books. Some chances you're going to find something important. So when people tell you about a book or you ever hear people talk about, have you ever read that book before? Not because you not buy it, no means so you can't have access to it. Because sometimes when the books are much older, you find people will put the entire version of the book on Google. Rosemary, good evening. On Google Books. So that's a place to find a lot of reading material. Google Books, if you're just looking for books and so on to read. Google Scholars, if you want to do more academic type reading, you go to Google Scholar. But let us use those tools to our benefit. Remember one time we have to walk the library. We have to wait till we get one children one, especially those of us who did poor one government reading book. We were really deprived of reading and reading materials growing up. The World Wide Web provides you the opportunity to read broadly, to read globally. And I'm advising you to make use of it to inform yourself. When you inform yourself, people can fool you, or you can swallow people poison chalice and take every word themselves for gospel, because you can go there, go do it yourself. So make it a part of what you do as well. Some of us don't like reading. Just read a paragraph a day. There is going to be something in that one paragraph that you might learn, that might highlight something to you, that might enlighten you in some ways. So try doing something like that as well to advance your own knowledge. It is what the journey is about. It's called continuous education. Continuous education. And that is what is going to take us out of this mental slavery. We will not be able to come out of the system without de-brainwashing our minds and informing our mind with the right information that suits your spirit, not the spirit of the corporation and the plantation owners. And before I end, let me just remind you of the state of play of justice system and world affairs for humanity, but especially to do with us Black people.
Really use words of art to make you believe, in fact, that law is on the table when you walk in. Use law, really use words of law really is. Most of us think that we go into a courtroom and understand the difference between a court and a courtroom, that the people who purport to use law really use words of art to make you believe, in fact, that law is on the table when you walk into a courthouse or a courtroom, when in fact that's not true. And I would like to share with you tonight, regardless of your religious persuasion, what law really is. Law, and as Muslims would say, all law, is A-L-L space L-A-W. All law. All law. So for anyone who's of a Christian persuasion, don't be misled. And when you hear the term Allah is God, all right, that is also what we would say in lawful terms a misnomer. Allah is not God. God has no capacity and no standing to all law. Because God means governmental ordinance departments. There is no comparison. Now, who can use law? Law can only be used by people who are in their sovereign capacity. And as I will share with you tonight, the majority of the people in the world, and I'm not going to get into all of the details about that, but the majority of the people in the world, 99% of them live in slavery today. So in 1863, via the Emancipation Proclamation, and I challenge you to go look in a law dictionary and look up the definition of emancipation and proclamation, and you will see that a proclamation is not a law. A proclamation is a public announcement by elected officials. It is not a law. So the Emancipation Proclamation of 1863 did not set any slaves free. What it did was standardize slavery, the United States being the model for the standardization of slavery, that all of the other nations around the world, as they reduced their people from their sovereign capacity and forced them to join nation states, they are in a corporate ward status, meaning that they are wards of the state. They are members of the corporation, which is a nonprofit, that calls itself the Commonwealth of Pennsylvania. And as long as they have a birth certificate on record with the Commonwealth of Pennsylvania, with that birth certificate being a contract, a birth certificate is a contract. And as long as you have a contract with the Commonwealth of Pennsylvania Incorporated, you belong to them. And that's what slavery really is. All right? So who can use law? If you are a member of a corporate ward state, if you are a member of a corporate ward nation that calls itself the United States of America, you are a citizen. Look in the law dictionary and look up the definition of citizen. A citizen is not a sovereign. A resident is not a sovereign. Therefore, if you use an address, which is a fictitious number associated with a designation issued by a corporate ward, right? Then you become under the jurisdiction of those people who are also corporate wards, but who are also slaveholders. All right? So if you are operating in that capacity, law does not apply to you. If you are a resident of the city of Philadelphia, which is a private nonprofit corporation, and you say you are a resident of the city of Philadelphia, then the ordinances and the resolutions of that private nonprofit corporation apply to you. If you are a citizen of the Commonwealth of Pennsylvania Incorporated, which is a private nonprofit corporation, then the statutes of that nonprofit corporation apply to you. If you are a citizen of the United States of America, which is a private nonprofit corporation, then the code of the laws, right, apply to you. But if you are a sovereign of the Moorish Empire, those ordinances, those resolutions, those codes, those statutes do not apply to you because you are not a member of the corporate ward state. It's as simple as that. And they understand the difference. This is why on their documents, they use words of art. They use the word label. They use the word person. They use the word address. All of these things that place you in their jurisdiction, and you unknowingly fill out forms every day. And every time you fill out a form, you enter into a contract. I don't care what kind of form it is. It's a contract. A driver's license application is a contract. A social security application is a contract. When you call up the telephone company and you make a verbal contract over the telephone, this is why they can bill you. When you sign a deed, it is a contract. When you fill out a voter registration form, it is a contract. Does everybody understand that? Don't ever think anything that you put your signature on becomes a contract. All right? Now, the fact that you are not in your sovereign status means that you make a contract as a minor. They don't care. They know you are a minor because, and to be other than a minor, I'm going to start with what law really is. Most of us.
Jamaica has its very own solution to remove us as a people from under that corporate structure and become sovereign people. What is he talking about? We all can become, apply for our maroon sovereignty. We can all become maroon and remove the jurisdiction of Britain from over Jamaica. Remove the jurisdiction of the West. We have our very own solution at home. Are we united to do it? Can we centralize our resources? Can we partnership? Peter Flynn and Delroy, good evening and welcome. Can we partnership with the Maroon community to remove the corporate jurisdiction? Open, good evening and welcome. To remove the corporate jurisdiction which continue to hold us in slavery and in contempt while continue. No, I'm not talking the LAID thing. I'm talking about our proper Maroon jurisdiction, turn the whole Jamaica under Maroon jurisdiction. By that, we remove the British administration. It takes unity to do that, though. Are we prepared? Are we prepared to unite to remove that old colonial jurisdiction from over us? Thank you all very much for being here this evening. I really, really appreciate your support. And if you have joined late, please listen from the start, as I dealt with two articles. An article written by P.J. Patterson and Hugh Small, KC, as well as today's Gleaner editorial saying the DPP did nothing wrong. So please do listen over. And thank you all for joining. And as always, if you have not hit the like button yet, please do so before you exit the program. Thank you all for being here, and I definitely will see you later on this evening. Thank you very much, and good evening from Global Television. This was Drive Time London.